Hello everyone, welcome back to this channel. In this video, we will take an overview of the entire CIRP process as prescribed under Chapter 2, Part 2 of Insolvency and Bankruptcy Code 2016 for corporate person. So let's quickly dive into it. In our previous video, we learned that insolvency under IBC comprises of three elements: the debt, the default, and a corporate person. As we discussed earlier, the entire CIRP or the corporate insolvency resolution process runs through a time frame of 180 days, and an extension of 90 days can be given by the adjudicating authority, and the relaxation of 60 days is provided to account for litigation. Within 330 days, the RP has to complete the resolution of the corporate debtor. Typically, in a three-step process, firstly, an application is filed in NCLT for initiation of CIRP. Second, the court appoints the IRP and the previous management of the company is suspended, after which the IRP or the RP runs the company as a going concern. Third, the resolution plans are invited and shortlisted by COC. If required, this time limit can be pushed for an extension of 90 days. However, if this process is not completed within 330 days and a resolution for liquidation is passed, the liquidator would have 365 days for the completion of the liquidation process. This resolution for liquidation can be passed voluntarily or will be automatically be imposed under circumstances provided under section 33. The court appoints a liquidator once an application for initiation of liquidation is filed. Now, the liquidator is required to sell the assets of the company, and the proceeds of the sale are distributed amongst the stakeholders as per the waterfall mechanism provided under section 53 of IBC. So, friends, once we have got an overview, let us now understand in depth as per the timeline prescribed under the code. So, friends, please note that the initiation date is different from the insolvency commencement date, and the timeline x equals to 0 is the insolvency commencement date. So, first, the application for the initiation of the CIRP is filed before the adjudicating authority by financial creditor, operational creditor, or the corporate debtor under section 7, 9, or 10, respectively. Further, the adjudicating authority may, by an order, accept or reject the application within 14 days of filing the application. Once the application is admitted, an insolvency professional, after referring to the board, the IBBI, and a consent form is signed by the IP on the day of commencement of the CIRP. Now, friends, there are certain qualifications under which the person is eligible to register themselves as an insolvency professional. First, if they have successfully completed the National Insolvency Program. Second, if they have successfully completed the Graduate Insolvency Program. Third, if they have a 15 years of experience from management. And fourth, if they have a 10 years experience as chartered accountant, a company secretary, a cost accountant, or an advocate. Once the IRP takes charge, it should make a public announcement to invite claims under Form A, announcing that this particular company is undergoing the CIRP. So on the left side, you can see the Form A, which shall be published. It should be published in two leading newspapers, one in English and other in regional language, where the corporate debtor has a registered office and or has functional corporate offices. Second, on the website of the corporate debtor, and third, on the website of IBBI. Now, within 14 days, all the claims need to be submitted by the stakeholders post this public announcement. The claim under the code has been defined as a right to payment or the right to remedy for the breach of contract. Now, typically, this claim can be received from two types of creditors, either financial creditor or an operational creditor. And these operational creditors can be further categorized into workmen, employees, government agencies, or creditors of class. Friends, this is the Form C, the claim form which is submitted by the financial creditors. Also, this is Form B, the claim form submitted by operational creditor except workmen and employees. So, we will learn more about these forms in our upcoming videos. Now, friends, under the code, it is the duty of the IRP to verify every claim as on the insolvency commencement date within 7 days from the last date of the receipt of the claims and maintaining a list of creditors containing the name of the creditor along with the amount claimed by them. Now, once these claims are submitted and verified, the IRP is required to constitute a COC or the Committee of Creditor and notify the adjudicating authority about the same. The interim resolution professional is required to constitute this COC within 23 days from the ICD. Also, the first meeting of the COC should be conducted within the 30 days from the ICD. One of the agendas in the first COC meeting is to confirm that the IRP will continue as a resolution professional. So, a new resolution professional can be appointed if the resolution is approved by the COC with a 66% vote. In case the COC is unable to decide, the previous IRP will be deemed to continue as an RP within the next 40 days. Now, once the RP has been appointed, the first duty of the RP is to appoint two registered valuers in each asset class: the security and financial asset, land and building, and plant and machinery, determining the fair value and the liquidation value of the corporate debtor. This appointment of the valuers should be done within the 47 days of the insolvency commencement date. The second major duty of the RP under the code is to submit an information memorandum to the Committee of Creditors. So, this should be done within 54 days of ICD. An information memorandum is typically like a pitch book that contains details like assets and liabilities of the corporate debtor, the annual financial statements, particulars of the debt, list of creditors, any ongoing material litigation, or any other relevant information that the buyer may seek. Now, simultaneously, while this process is ongoing, the resolution professional is required to determine if the corporate debtor has had any malintention which may have triggered this debt. So, friends, under the IBC code, the section 43, 45, 54, and 66 are of paramount importance, which indicates that if the corporate debtor has undergone any preferential, undervalued, fraudulent, or extortionate transaction. For the ease of convenience, we call them as PUFE transaction. Now, as per the timelines, the RP has to first form an opinion on the PUFE transaction within the 75 days. The RP is also required to publish Form G that entails the invitation of expression of interest or IEOI by prospective buyers or resolution applicants. The prospective resolution applicants, pursuant to publication of Form G, expresses their interest in the participation under the process as prospective resolution and also declare that they are eligible to be prospective resolution applicants. So the eligibility criteria typically includes like their net worth of the applicants, eligibility as per section 29A, submission of refundable participation money deposit. All of these parameters are left to the wisdom of COC to decide. Now, once this EOI is submitted, a detailed version of EOI, that is expression of interest, is circulated to all the prospective resolution applicants along IM, EM, and RFRP. This EOI is submitted within 90 days of insolvency commencement date or 15 days from the publication of EOI. The resolution applicant who meets the requirement of IEOI submits an EOI that is unconditional and consists of few basic documents like undertaking stating that they meet the criteria, relevant records in evidence to meet the criteria, and an undertaking that they are not ineligible under section 29A. RP issues a list of eligible provisional resolution applicants or the PRA within 10 days of the last date of EOI. Any objection regarding the inclusion or exclusion may be raised by the resolution applicants within 5 days of the issue or in circulation of the PRA list. On considering the objections, the RP shall issue a final list of the RA within 10 days of the issue of PRA. Parallelly, the RP is required to issue RFRP, that is Request for Resolution Plan, EM, the Evaluation Matrix, and an IM, that is the Information Memorandum, to the resolution applicants. Within 115 days, the final list of the resolution applicants is prepared. Now, these are the two major duties that the RP needs to take simultaneously. Now, these resolution applicants are required to submit a resolution plan as per the EM, IM, and the detailed EOI submitted by the RP. These resolution plans should be submitted within 135 days of the ICD. Now, friends, like we stated earlier, that RP is required to determine the PUFE transactions or avoidable transactions. Therefore, RP appoints a forensic auditor with the approval of the COC for a certain look back period. The RP is required to determine the PUFE transaction within 115 days. And thereby, the RP files an application to the adjudicating authority for appropriate relief. This filing of application before adjudicating authority should be done within 135 days from the insolvency commencement date. Now, our main process that is running simultaneously while the resolution plans are received, it is the duty of the RP to scrutinize the resolution plans and determine if they are compliant as per Regulation 38 of the CIRP, along with all the appropriate undertakings and the submission of earnest money deposit. Only compliant resolution plans are put to vote before the COC for their approval with 66% of majority. This should be done within 165 days from the insolvency commencement date. The resolution applicant is bound to furnish the performance security. This performance security is forfeited if the successful resolution applicant fails to implement the plan. The adjudicating authority is then requested to provide the approval to the accepted resolution plan within 180 days. If this entire process is not completed within 180 days, then an application for an extension of 90 days period may be applied on the instruction of the COC. So, friends, there are three parameters that the adjudicating authority, before approving a resolution plan, may consider. If the resolution plan submitted is in compliance with all the provisions under the IBC. Second, if the COC has approved the resolution plan. And third, if the SRA has submitted the performance guarantee deposit. However, if no resolution plan is received or the time for resolution has elapsed, the COC can approve for liquidation of the corporate debtor. Friends, we will understand more about the liquidation process in our next video. Until then, please consider commenting, share, and subscribing to support us and our work.